Hi, everyone. My name is Kate Holliday, and I'm the Operations Manager here at Lingia Law. Thank you so much for joining our webinar today on our 2026 Compliance Outlook. Today, Mallory Farrar will be leading the discussion on what to look out for and how to get your practice ready for the year ahead. Mallory, I'll hand it over to you.
Thank you, Kate, for that introduction. Hello, everybody. Thank you for joining our webinar. We're always really happy to kind of have this virtual FaceTime with our clients, especially when we have important topics to cover that might not be top of mind right now for you. That's the thing. We want to always be able to get ahead of things that could become issues. So today, we're going to talk about kind of just broadly this uptick in regulatory agency enforcement that we've seen, specifically with respect to med spas, wellness businesses, IV hydration and nutrition, kind of anything that falls into that category. If you were on our last webinar about compliance earlier this year, or if you work with me, you have heard me say many times that we're seeing a major uptick in enforcement efforts, and that continues to be the trend. And we see, no signs of that slowing down. So what that means for you is that there are a handful of critical key categories that we need to talk about, and then you need to think about your operational flow through those categories. So one thing that we're seeing a lot of are medical boards and nursing boards coming to talk to businesses about whether they are like their ownership is set up correctly and whether they have the right supervision. So many of you know that if you're in a state that has the corporate practice of medicine doctrine, in most cases, only a physician, and in some states, an APRN, can actually own that business. When we have that scenario, what we do is we set up the management services organization model where you, the person who's really running the show, have one business and your medical director has another one, and you guys contract, and that's how you run the business, retain the profits, etc. A lot of people don't know that they can't do that or that they can't own outright their own clinic. A lot of times we have registered nurses who've been practicing for 30 years. They're more competent than probably any of the doctors in their area, honestly. And it doesn't seem right that they wouldn't be able to own their own clinic, but in most cases they can't. So we're seeing boards coming into medical spas and they start asking you about your medical director and what kind of documents do you have and who owns this business? Where does the money go? And those are the questions they're going to ask you to get at whether you're violating the corporate practice of medicine. For example, in North Carolina, we've had a lot of investigations going on there that we've been assisting with. And several North Carolina board investigators have made it clear to us that they are focusing their enforcement efforts on the corporate practice of medicine and supervision issues specific to medical aesthetics and other wellness and IV businesses. So what that really means is now they've turned their lens on you and they're going to be scrutinizing you. Now, it's a big pool of people, right? We're all little fish in this big sea. What are the chances that I'm going to be the one who gets in trouble for something? So and so down the street has been doing it like this for 30 years. They've never been in trouble. That doesn't mean you won't be the one. And that doesn't mean that so and so down the street hasn't been in trouble and just you don't know about it. It's not something we want to talk about. So what you need to be thinking about is, am I structured correctly? Is my ownership set up correctly? And again, this doesn't apply to all states, but it applies to most states. Then you need to be thinking about supervision. Do I have my medical director in place? Is there a contract with that individual? And are they providing what would be considered adequate supervision? So these two issues, the corporate practice issue and the supervision scope of practice issue, kind of go hand in hand right now, because what we're seeing is the board will come to investigate one thing, they'll start digging around, and then boom, it becomes an issue about ownership and what is your medical director's role, i.e., what kind of supervision's going on here. So one thing that we're seeing all the time, and many of you may contract with medical directors who offer this type of service. Many of you may be medical directors who offer this type of service, telehealth medical director services. And that's a very popular model to use in medical aesthetics. And this is an instance where maybe you live in Arizona, your physician is licensed in Arizona, but they live somewhere else. So they provide virtual services to you. Well, right now, there are so many physicians out there who are licensed in every single state. And so they're providing these services everywhere. That's great. It's great that there's more access. But the problem is, some states are not going to be cool with that. Colorado, for example, if you're doing a medical director service in Colorado, you need to be physically in Colorado. Florida has restrictions on a radius of how close you need to be to a clinic. They restrict how many clinics a medical director might need to or is allowed to supervise. So you just want to be really sure that you know the laws in your state and that your medical director is able to comply with those. Another thing we see a lot are medical directors who really are just very hands off. And the role of a medical director is kind of hands off. That's why it's a really a really exciting and enticing thing to do. But they're still getting paid for something. So they have to be doing something. And that parity between what you know and what they know has to be there. And you need to be able to show that. And by that I mean talk to your medical director at least a couple times a month and make sure they're looking at your charts. Some states have a specific requirement, like 20%. Some states don't have a requirement. In that case, every couple months get together and look at, 20% of charts, discuss clinical issues, and document those conversations. Doesn't have to be a specific format. Just create a log where you say, we met on this date and we discussed XYZ. That is really helpful. Something I always say to clients is, yeah, you can pass with a C, but don't you want the A plus? Well, complying with the law will get you the C, but going above and beyond will get you that A plus, and those are the teacher's pets. So we want to be in that position with the board investigators. So make sure your medical director is allowed to practice where they're practicing. The most important thing with that is wherever the patient sits when the supervision occurs, they need to be licensed there. So those are just important things to keep in mind if you are working with medical directors who offer that kind of service, or if you are one and you have any questions, please reach out. We know the ins and outs of those laws, and we really want to help everybody be successful, because whether you're our client on the clinic side or on the medical director side, the best relationships in business come from a place of equality and looking out for each other. And that's what we want you to achieve on all sides. So that's part of the medical director supervision that's being kind of really scrutinized by boards right now. Hand in hand with that is scope of practice. So depending on the state you're in and depending on how your specific board interprets something, so that's, the Board of Medicine, the Board of Nursing, et cetera, you are going to have like a scope of practice that could be limited, it could be broad. And just because you've been doing something, say, for example, you work in a hospital and you work in the emergency department and you run IV lines all day long, you assess patients and make decisions all day long. Hospital rules are different than your own practice. In certain cases, you are not allowed to diagnose a patient. That has to be done by a physician assistant, an APRN, or a physician. In some cases, if you are running IV lines or adding things to that, certain boards will consider that compounding. Now, the IV regulations, you might be thinking, oh, yeah, let's talk about that. I've heard a lot about that. That is a conversation that deserves its own full-time webinar. Of course, please come to us with any questions. But yes, IV therapy and nutrition clinics are being targeted right now. And there is a question, both at the federal level and the state level, as to whether when you are putting together these bespoke cocktails for clients who come in the door and say, hey, I want the hangover cure or the woman's vitality boost, those kinds of things. There's a question as to, are you actually compounding? And if you are compounding drugs by adding them together, do you need a pharmacy license? Do you need to comply with federal standards? Do you need to have infrastructure like a laminar flow hood and, defined aseptic techniques that everyone's been trained on very specifically? That is a very gray area right now. But as those businesses continue to boom everywhere, boards are laser focused on that. And, something we see a lot, like if you're thinking about being a board member, whether it's a medical board, nursing board, board of pharmacy, They all talk. It's a small world, really, when you think about how many regulators are out there across the country. They talk to each other. But now what we're starting to see is them kind of joining forces. So you might get a complaint filed to the Board of Nursing. They come by to investigate. They call the medical board and say, hey, you might want to check out their medical director. And then they also call the pharmacy board and say, hey, they might be compounding. You might need to go check that out. Well, guess what? Then you potentially have three investigations on your hands. Even though you might be a nurse, so the Board of Medicine and the Board of Pharmacy don't directly regulate you, they still have the option of coming after you for aiding in the unauthorized practice of medicine or the unauthorized practice of pharmacy. So the point is here, even if you could mix IV bags and run lines in your sleep, that's not going to satisfy the legal requirement necessarily. So again, the IV regulations are very state specific. They're very product specific. If you have questions about that, please reach out. We're happy to talk about it, but it is a pretty big topic that really requires digging into those facts. So those are kind of the things we're really seeing right now the most from state regulators. Again, they're just paying a lot more attention to this space. They're looking specifically for issues with the ownership and structure, and they're looking for issues of a lack of supervision leading to someone potentially exceeding their scope of practice. So be sure you know who is allowed to do what. You might have an esthetician who is the best that you've ever met, and she's been doing this for 20 years. She's still not allowed to do a lot of the things that we would think an esthetician can do. For example, in many states, estheticians cannot perform microneedling. Who would have thought? But it's important that you know what license and or qualification all of your staff have and what are they allowed to do within the bounds of their scope. That's very important. And that feeds back to the supervision piece too. Your medical director needs to know what you're doing and they need to approve what you're doing. So these things all work together and they're each integral pieces. If a piece isn't right, the rest can fall apart too. So we just want to avoid any of those instances or situations happening to you. The next thing for switching gears that I wanted to talk about has to do more with federal enforcement, specifically energy-based devices. So we know how popular these are. Lasers are amazing. IPL can do wonders. RF microneedling devices, so many people love those treatments. But we're starting to see a lot of scrutiny around how safe are these devices? Are they ablative or not ablative? Does the word invasive even matter at this point? And who can perform these? So, with these types of devices, the risk is always a little higher than, for example, a light chemical peel. The FDA actually on October 15th released a safety warning letter that focuses on RF microneedling devices. The FDA has been getting an alarming number of adverse event reports of people reporting having permanent nerve damage, tingling, numbness, pain, people having permanent scarring from burns, unintended fat loss, in the areas being treated. So those are things those aren't your standard side effects, right? That's not like you might experience swelling. You're going to have some redness. You might be sore. These are much bigger risks. And so with respect to microneedling devices, what do you need to do? If you're using RF devices, what you need to do is immediately adjust your consent forms to say, hey, there are some serious risks associated with this. And here they are, and let me explain them to you so that you know what you're going into. That needs to be in your consent form. When it comes to your marketing, you can't be saying, oh, RF microneedling is safe. It's low risk. Those things, according to the FDA, are no longer true. I mean, safety, of course, is subjective based on how it's being performed, who is doing it, et cetera, et cetera. And of course, we can't control what patients do when they go home. We can't control whether they're going to go home, light up a cigarette, drink a bunch of wine and sit out in the sun all day, things that are not going to help with their aftercare. But the bottom line is, if one of these serious events occurs and somebody sues you, which, by the way, very well could also open up a board investigation, there is now federal information out there saying, hey, We warned you that this was dangerous. Now you can't act like you didn't know or like it's not common. That doesn't matter. It's possible, and you should have told your patients. So make sure that you modify your consent forms to cover these new risks. Make sure that you are, again, your marketing is not making claims that would be directly refuted by the FDA. It's not just RF microneedling devices. Maybe that's what the FDA focused on in its safety letter, but we got to think about what is energy based. That's going to be most of your lasers, ultrasound, IPL. All of those things are going to be considered energy based devices. And we are seeing a lot more state scrutiny of those types of devices as well. I feel like one of the biggest gray areas that we help clients with is, can I use a laser? What kind of laser am I allowed to use? Do I need on-site supervision, et cetera, et cetera? Most states aren't very clear on that. Some states are. In Georgia, pretty much anybody who has some level of medical licensure can perform laser stuff, but they have to have a special laser technician license and they have to be supervised by a special laser technician. The license is not difficult to obtain, from what I understand, but it is a requirement. In some states, and this will kind of be the introduction to a landmark decision we've seen recently. So in New York, laser hair removal, not really regulated as medical, and that's always been kind of a unique thing about New York. However, recently, the New York Medical Board brought down an interpretation of its own rules and said, hey, lasers, RF microneedling devices, IPL, any of those things, those are medical procedures, and that is the practice of medicine. So where we had a gray area and we could kind of argue that, an RN should be able to do this, or an esthetician with the proper training should be able to perform IPL. We used to be able to kind of argue that because there was no law against it. There's a difference in the law saying you can't do something and there not being a law, which essentially means maybe I can do this. It's a risk area. But now in New York, it's pretty clear. There are people who are fighting back against that. There are people asking for more clarity on it. And we definitely anticipate the board kind of, walking us through this new interpretation to an extent. But the point is, that is what they're saying right now. And at least on the surface, that sounds pretty clear. If you are using these devices, you are practicing medicine in most cases. Again, it's a brand new interpretation. And, laws evolve, interpretations grow. We kind of have to see how everybody reacts to these things before we see more changes. But we do anticipate other states following suit and starting to more highly regulate these things. So you just always need to be thinking about, what is this device capable of? Not how should I be using it, but what, if we think about the worst thing that could happen, what is that? Let's work backwards from there. Let's make sure all our staff are very well trained. Let's keep those training certificates in a binder on site. Let's make sure that supervision is adequate if it's necessary. Let's make sure that the patient is well aware via their consent forms of every possible thing that could happen after having an energy-based device treatment. And another thing that's important, just because a device is popular and well known, doesn't necessarily mean that it's fully above board. So one helpful tool that you might use is you can go to the FDA's website and you can search for warning letters, orders to make corrective changes, the revocation of certain licenses and manufacturers, et cetera. You can plug in your specific device and then you can go and see if there have been adverse events reported or if the company has been doing anything shady they've gotten in trouble for it. Also, just the regular old Google search, still really effective. I would put in the name of the device and then adverse effects in your search bar and see what comes up. Obviously, the internet is kind of the Wild West. You need to use your own clinical judgment about anything that you read and make your own professional decision about what you think the risks are. But just be aware that this is now something that agencies are looking at. And we also see a lot of patients who are trying to sue somebody. A lot of the times these are energy-based devices. In this space, you kind of never know what you're going to get because the outcome is subjective. And only the patient can make those subjective decisions about how they think things turned out. So just cross all your T's, dot all your I's, make sure that you're properly supervised, you're properly owned, you document everything, you get consent forms that have been updated to include any and all risks, even if in your head you're like, well, if I saw that, I'd probably not get this procedure. Trust me, not everybody's going to walk away, and you would much rather lose a little business than get in trouble for that and have it stop your operations. So that's really all we wanted to talk about today. Again, everything that we discussed is going to vary by state. It's going to vary by profession. It's going to vary by the type of procedures you're offering. If you have any questions, we would love to talk to you. We're always here to help. We love what we do, and you're the people who let us do that. So, as I always say, if you stay ready, you don't have to get ready. Let's make sure you're ready. So, just give us a call if we can help with anything. And thank you again for joining us.